Courtroom drama in the Thabo Bester saga took another unexpected turn on Tuesday, the 17th of June 2025. What was meant to be a routine pre-trial hearing to confirm readiness for the highly anticipated trial set to begin on the 21st of July spiraled into a tense legal chess match, revealing delays, unresolved disputes, and cracks in the defense's preparedness. Before we continue, I'd like to thank you for the subs, likes, shares, and comments. It really helps us, a small self-funded media publication, in our mission to tell South African stories in a meaningful way. We will be relaunching our podcast, Crime Central South Africa, with a thorough deep dive into the Jocelyn Smith case that will premiere soon on Spotify and Apple Podcasts. Links to those we will leave in the description. We'll also soon be launching Season 2 of Unsolved Murders SA, a podcast series that focuses on unresolved cases in South Africa, particularly those that have grown cold over the years. Back to the video. At the center of this session was Zolile Sekeleni, the father of Dr. Nandipha Magudumana and one of the co-accused in the prison break conspiracy. Sekeleni stood before the Bloemfontein High Court with no legal representation, a violation of a basic constitutional right in South Africa, the right to a fair trial, which includes access to legal representation. According to the record, Sekeleni applied for assistance through Legal Aid South Africa, a state-funded program providing legal support to individuals who cannot afford a lawyer. However, his application was rejected back in January 2025 due to his assessed financial means. What raised eyebrows was the timeline. Defense attorney Kruger told the court that Sekeleni had previously indicated he would not appeal the legal aid decision, opting instead to try and secure representation through his daughter's legal counsel, advocate Machini Mutlaung. However, hours before this court sitting, it emerged that Mutlaung had been inundated with cases, not least of all his ongoing representation of Dr. Nandipha, and had apparently not agreed to formally represent Sekeleni. Standing in court, Sekeleni told the judge he had no lawyer and was now officially appealing legal aid's rejection. The judge cautioned him, and rightly so, that acquiring a new lawyer this late in the process could severely compromise his ability to prepare for trial. While the court acknowledged the seriousness of this appeal, the concern was about timing. With roughly 1 month to go before proceedings are due to begin, any legal delay now puts the entire timeline in jeopardy. However, Kruger reassured the court that the appeal process could be fast-tracked and likely finalized within the week. In the event it fails, advocate Mutlaung said he would be willing to step in, a crucial safety net to ensure the trial is stalled indefinitely. The court's concern was clear. With over 5,000 pages of documentation submitted in the case file, any delay in legal preparedness is no small matter, yet Sekeleni's appeal wasn't the only roadblock on the day. Bester's own legal team made it clear they are not ready for trial on the 21st of July. His lawyer told the court that there's still a pending application for access to electronic devices and video footage, which are supposedly central to Bester's defense. This application, first raised last year, has been bouncing between criminal and civil jurisdictions. Its unresolved status is yet another variable threatening to delay proceedings. These types of requests fall under discovery rules, the part of the legal process where the defense and prosecution exchange information or evidence. In this case, the defense argues they cannot adequately prepare for trial without the requested materials. To complicate matters even further, one of the accused, Teboho Lipolo, a former CCTV technician, showed signs of severe health distress in court. Proceedings were temporarily paused when he began struggling to breathe. The court resumed in his absence. Elsewhere in the dock, two accused, Zanda Moyo and Joel Maketa, confirmed they would accept legal aid representation. That settles part of the representation puzzle, but not all of it. Then came a very bizarre moment in proceedings. Bester's lawyer asked for permission for his client to sit in place of Moyo, who was seated next to Magudumana, Bester's former lover, during proceedings to receive instructions from Bester. Why did Bester want to sit next to Dr. Nandipha, who throughout the trial looked visibly distressed? The court rejected this, instructing instead that Bester raise his hand if he needed to communicate during proceedings. The judge deferred broader consultation logistics to correctional services, noting that while the court would not enforce post-hearing consultations, an informal agreement was reportedly in place allowing for 1 hour of post-court discussions between the accused and counsel. But perhaps the most telling development came from Dr. Nandipha Magudumana's side. Her legal team confirmed her extradition case, where she's fighting to have her return from Tanzania declared unlawful, is now before the Constitutional Court. This process, while technically separate, is deeply tied to the main trial because it could challenge the legitimacy of her arrest and potentially affect how evidence against her is weighed. The elephant in the room, whether the trial will go ahead as planned. With all these unresolved matters, a pending legal aid appeal, an ongoing extradition challenge, a delayed discovery application, and at least one accused showing medical distress, the judge was visibly concerned. And the defense made it clear they were confident that the matter would not be trial ready by the 21st of July. Before closing, the court acknowledged the withdrawal of charges against accused 5, Buti Masukela, a former G4S security guard, marking a rare moment of closure in a case that has grown only more complex with time. The case management hearing has now been postponed to the 19th of September 2025, a date meant to confirm all remaining administrative issues ahead of the new trial window, which will run from the 10th of November to the 5th of December 2025, with continuation from the 19th of January to the 29th of March 2026, should more time be needed. So what was expected to be a mere box-ticking exercise turned into a reflection of just how logistically and legally entangled this trial has become. And with South Africa's most sensational criminal case hanging in the balance, all eyes are once again on the Bloemfontein High Court. At the heart of Thabo Bester's pre-trial defense strategy lies a critical application that could determine how and when his trial proceeds. This application, lodged in the Free State Division of the High Court, sentence on a procedural dispute that's anything but trivial: access to key electronic devices and CCTV footage that Bester argues are crucial to preparing his defense. The background is this. Bester's legal team claims that various electronic items were seized by the police during the state's investigation, and to this day, full access to the data on those devices has not been granted. This includes digital materials like cell phone records, surveillance video footage, and laptop content, much of which allegedly forms part of the evidence that the state will use in prosecuting the case. In the court papers, Bester argues that without access to this data, he cannot adequately challenge the state's version of events. His legal team is asking for an order compelling the National Director of Public Prosecutions, the head of Crime Intelligence, and the head of SAPS to hand over the contents of these devices for inspection, analysis, and possible duplication. This falls under a principle in South African law known as quote-unquote disclosure or discovery, where the accused has a constitutional right to be informed of the case against them and to have access to any material that could help in their defense. The foundational framework for this right is Section 35(3)(b) of the Constitution, which ensures every accused person's right to a fair trial, including the right to be informed of the charge with sufficient detail and to have adequate facilities to prepare defense. However, the state, according to previous correspondence, has either delayed or denied full access, citing issues such as the integrity of ongoing investigations or chain of custody concern. As a result, Bester's team has been locked in a standoff with the prosecution over whether he has received full disclosure and whether the trial can proceed without it. This legal filing represents Bester's attempt to resolve that, not through a motion filed within the criminal trial itself, but via a civil application separate from the main case. The unusual step of pursuing a parallel civil proceeding is indicative of the urgency with which his legal team views this issue. In the papers, Bester's legal counsel argues that it is quote-unquote fundamentally unfair for the state to proceed without affording him full access to the seized material. They claim this would violate the principle of equality of arms, the idea that both the prosecution and defense must have a fair opportunity to present their case and respond to the other side's argument. If this application is granted, it could stall the trial further, forcing the state to open its full digital archive to Bester's defense and possibly restart certain phases of pre-trial preparations. If denied, it could limit the scope of Bester's challenge during trial, leading his team to argue potentially on appeal that his right to a fair trial was compromised. So far, there's no indication that the civil court has ruled on the matter, but as of the 17 June 2025 hearing, Bester's legal representative made it clear, without access to this evidence, they're not ready to proceed with the trial. While the countdown to the Thabo Bester trial was meant to accelerate toward a July 2025 start, another legal roadblock has emerged in the form of Dr. Nandipha Magudumana's drawn-out legal campaign to invalidate her extradition from Tanzania to South Africa, and although her latest attempt has failed, the implications of this ongoing challenge continue to hover over the trial like a storm cloud. In May 2025, the Supreme Court of Appeal dismissed with cost Dr. Magudumana's appeal against the previous High Court ruling, which had already rejected her claim that she was unlawfully abducted by South African authorities in Tanzania. The essence of her case hinged on a serious allegation that her arrest was not a lawful deportation but a disguised extradition carried out without legal due process and therefore unconstitutional. To unpack this, it's important to understand the legal framework of extraditions under South African and international law. A formal extradition process requires a state, in this case Tanzania, to assess a request from another state, South Africa, and only then hand over a suspect if a local court authorizes it. This process is governed in South Africa by the Extradition Act of 1962 and in a broader regional sense by the SADC Extradition Protocol. Dr. Magudumana's legal argument was that this process was entirely bypassed. She claimed that she was blindfolded, taken by force to an airport and then flown to Tanzania in a private jet, all orchestrated by members of the South African police. According to her, this amounted to state-sanctioned kidnapping disguised as deportation. In short, if the arrest had indeed occurred on Tanzanian soil without due process, it would have been unlawful, and any trial in South Africa that followed could be challenged as a constitutional violation. But the SCA disagreed. In its majority ruling, the court found that South African officials had not in fact arrested Magudumana while in Tanzania. Instead, the Tanzanian government had classified both her and Bester as quote-unquote prohibited immigrants and opted to deport them. They were then handed over to the South African High Commission, which arranged their return flight. Importantly, the court also noted that Magudumana appeared to have consented to her return. While she later contested this, the court ruled that her version of events did not contradict what she had said at her earlier bail hearing, where she had blamed Bester for coercing her to flee South Africa, applying the Plask-Evans rule, a legal principle that resolves factual disputes by accepting the version of the party that did not bring the application, unless it's clearly untenable. The SCA sided with the state. However, this wasn't a unanimous decision. Justice Makgoka, in a dissenting opinion, strongly criticized the ruling. He argued that no formal deportation or extradition process had been followed, and he rejected the notion that Magudumana's alleged consent was valid, stating that, open quote, a valid consent can only be given with full knowledge of the rights being waived, not after the fact, close quote. According to him, the authorities had failed to discharge their burden of proof to show that the process was lawful. So where does this leave Magudumana? Her next and final legal recourse lies with the Constitutional Court. If she files an application for leave to appeal to the Apex Court, she must convince it that her case involves a constitutional issue of public importance, namely, whether a state can effectively bypass extradition laws by labeling a removal as a deportation. If the Constitutional Court declines to hear her case or rules against her, her legal options will be exhausted and her participation in the Bester trial will proceed unimpeded. However, if the court takes up the case and finds in her favor, it could trigger an unprecedented scenario, possibly even invalidating her arrest and raising questions about the legality of the entire prosecution. This is why her pending application matters. While the SCA's ruling has paved the way for the trial to continue as scheduled, any pending action at the Constitutional Court and whether or not it issues an interim interdict could disrupt the proceedings once again. What began as a horrific fire inside Cell 35 of the Mangaung Correctional Center on the 3rd of May 2022 would, over time, unravel into one of the most scandalous prison breaks in South African history. The cell was engulfed in flames in the early hours of that morning. Inside, a charred body was discovered. That body was hastily identified as Thabo Bester, a man who by that point had already earned infamy as the quote-unquote Facebook rapist, a convicted serial rapist and murderer who had used online platforms to lure his victims. Soon after the corpse was found, the Department of Home Affairs issued a death certificate for Bester, accepting the claim that he had died in prison. But that story began to unravel in the weeks that followed. A second autopsy revealed the truth. The man who died in Cell 35 had suffered blunt force trauma to the head. He was murdered before the fire, and DNA tests confirmed that the body was not Bester's. The man declared dead was, in fact, a John Doe. The conclusion was inescapable. Thabo Bester had escaped. How? The pieces of a puzzle point to an escape meticulously orchestrated from the inside. Bester had requested to be transferred to an isolation cell just before the incident. The approval for that transfer was rushed through on a weekend without oversight from the Judicial Inspectorate for Correctional Services, which usually handles such matters. On the 29th of April 2022, just days before the fire, a vehicle entered the prison with a large TV stand cabinet. It was never checked. Footage of its entry vanished. A corpse is believed to have been smuggled in via that cabinet. Meanwhile, Bester used his access to a personal laptop and a contraband cell phone to coordinate final details of his escape. At least 7 G4S employees were later fired for their roles in the debacle, yet questions about institutional complicity remain. In the early hours of the 3rd of May 2022, a fire was reported in Bester's isolation cell. The response by prison officials was delayed by over 90 minutes. By the time the fire was put out and the body found, Bester had already slipped away, possibly through an emergency fire exit which should have been monitored. Despite the suspicious circumstances, it took the South African police more than 3 weeks to reclassify the case as a homicide. A full-scale investigation into the escape didn't begin until January 2023, months after Bester had begun a new life in hiding. By then, he'd reunited with his alleged partner and enabler, Dr. Nandipha Magudumana. The two were living under fake identities in a Hyde Park mansion and later as fugitives across South Africa and into East Africa. They were ultimately tracked down and arrested in Arusha, Tanzania in April 2023, nearly a year after the escape. South Africa's government had to negotiate a diplomatic return. Despite initial claims that Magudumana's extradition was unlawful, she was brought back alongside Bester. Her challenge to the legality of the process remains unresolved in the Constitutional Court. Since their rearrest, the couple and their co-accused, 9 in total, have faced mounting charges ranging from fraud and corruption to aiding and abetting escape from lawful custody, arson, murder, and defeating the ends of justice. The saga has laid bare the severe shortcomings in South Africa's prison management and criminal justice oversight. Parliamentarians were scathing in their assessments. G4S, the multinational security company contracted to run the Mangaung Correctional Center, was repeatedly slammed for its gross negligence and apparent internal collusion. Worse still, the judicial and prosecutorial processes that followed had to contend with the fact that nearly every institutional safeguard, from cell inspections to surveillance protocols, was either bypassed or ignored. The Thabo Bester case is no longer just about one man's escape. It's about the rot that allowed it. It's about the system that enabled it. And now, as Bester and his co-accused return to court, the nation is watching, not only to see if justice is done, but to see whether South Africa's institutions are finally ready to confront their own failures. This brings us to the end of our breakdown. If you made it this far in the video, thank you for watching. If you found this breakdown informative, subscribe and turn on those post notifications. Remember, we have more content planned, more cases to unpack, and true crime stories to dive into. So believe me when I tell you, subscribing to our channel and turning on those post notifications is absolutely necessary. Also, visit our news website, swisherpost.co.za, for the best explainers on every important event happening around you. No agenda, just the story.